Duncan here from Duncan Legal, here to answer another burning question. Just last night I was at a networking event and someone came up to me and said, "Hey, I just moved here from California and I already have an estate plan. Do I need to redo it or is it still valid?" Well, the answer is yes, it's still valid. In the state of Colorado, your will or your trust is valid until such time as you revoke it. So it could be in place for 20 or 30 years, depending on how long ago you did. If you moved from state to state, it's still valid. However, it's always a good idea to call and make an appointment and make sure it's still what you want done and it conforms with what Colorado is saying as opposed to what California would say. That makes a big difference sometimes because Colorado is not a community property state. So you might want to make changes at that time. But if you were moving in from Wyoming, that wouldn't be a problem because they are an equity state just like Colorado. But what happens if you lose your trust or your will, such as when the Marshall Fire happened and 800 plus homes burned down? Well, unfortunately, under Colorado law, if we can't find the original trust or the original will, the law says you must have revoked it. So if something like that happens, you definitely want to come back in and get those documents re-signed, because at that point, if it's revoked, then you are under the do nothing plan and Colorado is going to dictate where your assets go. And that might not be what you really want. Whether you just want to make simple changes, or you just moved here from another state, or you just lost the original one, give Duncan Legal a call, schedule an appointment, and let's discuss your options.